Hi everyone, my name is Shazia Khan and the learning outcome we'll be doing today is learning outcome 4 for business law for managers. I just want to go through first before we go on to learning outcome 4 is going through learning outcome 3 and just giving you a recap of what we did in the last session. So learning outcome 3, we looked at elements of understanding key business related laws, so the elements of why these laws are important when we deal with businesses and why the laws are needed to be followed, so the definition of the laws and examples of that. We looked at consumer law and we looked at false advertising, health and safety, fit for purpose, satisfactory quality. We looked at contract law, the law of tort. There was a video there for you to watch in your own time, looking at the legal basics of UK businesses. We also looked at understanding key business related laws. So contract law, we looked at the definition, the importance, and gave an example of that. We then went on to look at employment law, gave a definition, importance, and looked at the example in relation to the Equality Act 2010 and the 9 protected characteristics. We went on to consumer protection law, as I mentioned earlier, fit for purpose, making sure that products are of good quality and standards. We went on to company law and looked at the Companies Act in relation to how a company is formed and the structure of a company. Health and safety laws, intellectual property, competition law, and why the relevance of the Competition Act 1998. And we looked at environmental law as well. We then went on to describe the features of consumer law in more detail. Things like false advertising, and as I mentioned earlier, the legal requirements, the consumer protection with reference to an example, health and safety in regards to consumer protection and how it imposes a liability on businesses for defective products that harm the individual or the public. We then went on to look at the element of fit for purpose and under the Consumer Protection Act 2015, what that means. We looked at satisfactory quality under the Consumer Act 2015 and what that means in regards to a product, whether it's looking at the element of durability, appearance and performance of the product, as well as, defects of that product. We then went on to look at the key features of contract law, why that's so important within a business and why there's a need to have contract law. So, for example, it's an agreement between 2 or more parties to make sure that it's a legally binding agreement and make sure that parties agree to that agreement. We looked at what offer was within contract law, the definition, importance, and gave an example. We then went on to look at acceptance, definition, importance, and example, looked at consideration and intent within contract law, and also we looked at the element of describing features of law of tort. We looked at possession of rights and the violation of rights, injury, definition of that, importance and example, types of torts. So we look at negligence, intentional torts, or strict liability. And we also looked at the key features of international laws, why that's so important for businesses and why that's so important to maintain peace and ensure fair treatment of nations across borders. We looked at international economic law, key components, trade laws, investment laws, and financial regulations. We then went on to look at international security law with reference to uses of force like the United Nations Charter, the UN Security Council. We looked at the disarmament, peacemaking, and the importance of this within the global economy. We then went on to look at international criminal law, the definition, the accountability, the key components. We looked at international criminal courts, which is refers to the ICC, and how it prosecutes individuals for crimes such as genocide, war crimes, and crimes against humanity. We then went on to look at the importance of the international criminal law within the global setting, and also looked at ad hoc tribunals, which is International Criminal Tribunal for former Yugoslavia. And that was learning outcome 3. So we looked at key elements of learning outcome 3. There is an overlap between some of the most of the learning outcomes. So learning outcome 2 and 3 overlap. But now we'll be looking at learning outcome 4. And there's also an overlap in learning outcome 4 that you'll be able to address when we're looking at elements of impact of legislation on businesses. So the learning outcome 4, understand how laws impact on businesses, why they're so important, why there's a need for laws. So the indicative context for this is we look at self-employment, individual registration, incorporation, data protection, health and safety, consumer laws, employment laws, duty to fulfill a contract, protect both parties, legally binding, mediation, arbitration, and litigation. So key terminology. So self-employed, this is where, if any of you are falling to apply, you carry on a trade or business as a sole proprietor. Data protection is the process of safeguarding material, and a duty to fulfill a contract is a legally binding contract between the business and an individual. The video I've got here, which is a really interesting video, and it's by the 2 teachers, and it would look at elements of the impact of legislation on businesses, legislation and businesses, and how they play a key role in the impact of any sort of law on businesses. So understand how laws impact on businesses. Businesses of all sizes and all sectors are subject to any sort of wide range of legislation, which could have a tremendous impact on their operation and profitability. So, any business, has to run with legislation in place, and it's so that it affects businesses and it makes sure that all businesses comply with the wide range of laws that are in place, and from health and safety laws to tax laws, data protection, and it makes sure that the businesses are complying and making sure that they're monitoring the laws. And sometimes these laws can be really complex and time consuming, and businesses must often invest in legal advice, training and equipment to ensure they're compliant. Because if they're not compliant with these, then, they are breaching the law, but breaking the law as well. And an example, which we'll go through a little bit later, is GDPR. Businesses in the UK need to comply with the General Data Protection Regulation, GDPR, which came in force in 2018. And in detail later on, we'll look at the GDPR, but this legislation requires businesses to protect any sort of personal data of their customers and employers, and report data breaches of information to the ICO, which is the Information Commissioner's Office. And, complying with elements of GDPR can be costly, as businesses have to invest in new software, new systems, staff training to ensure that they are fully compliant. Legislation can have a significant impact on businesses, both in terms of compliance and in the consequences of not meeting the legal obligations. So, key areas where laws impact on businesses. So the first one we're going to look at is elements of, business formation. And that's really important, business formation. So company law, the impact is that, the business, how the business is structured. So whether it's a sole trader, whether it's a partnership, a PLC, these have to be registered with Companies House, and Companies Act sets out the legal framework that they must follow. So when a company is followed, so it looks at statutory obligations, ensuring that the companies are following the legal obligations, and making sure that, directors are in place, stakeholders are in place, and what their duties are, and they know of that. So business formation within company law is really important, because they need to be able to identify elements of why a company, is, how they are structured, so the structure of a business needs to be registered with Companies House. An example I'll give you is a freelance graphic designer operating as a sole trader bears personal liability for business debts, unlike a big tech startup company structured as a limited company, which offers its own liability protection. So it's really important that these legal requirements are followed. So the next one we look at is employment law. Why that is so important within any sort of business. Why there's a need to have employment law in place. Employees must be given a written contract within an organization. They must follow the legal requirements. It's there aimed at protecting individuals' rights, as health and safety of an individual. If you as a business employ staff, you need to be clued up with the law around it. This covers a wide range of issues, from things like, hiring people, the national minimum wage, working hours of the individual. For instance, limited companies, what staff they take, how they hire, how they fire, workplace safety, redundancies, discrimination, workers' right. You need to keep up to date with the law as a business to avoid any sort of costly disputes, or maintain a productive workforce. For example, in a care home sector, compliance with employment law includes ensuring all staff, from nurses to support workers, are properly trained and certified according to healthcare regulations. This includes regular training updates, fostering a discrimination-free workplace, and adhering to legal protocols for staff redundancy. So they have to treat their staff fairly. They have to make sure that they provide a safe working condition. And also, things like, discrimination, complying with the laws, complying with the company's policies as well. So these are really important in regards to that. Next one we're going to look at is consumer protection, and why that's so important in regards to consumers' rights, why there's a need to have consumer protection in place. This is really aimed at businesses to make sure that businesses act fairly towards their consumers, especially since consumers are sometimes in a much weaker financial position. The main consumer legislation that we deal with is things like Sale of Goods and Supply of Goods Acts, trade description, and consumer credit and consumer protection as well. And its consumer protection actually imposes additional cost to businesses, since they have to comply with the law. If they do not comply with the law, they risk fines and, having court orders against them because they're not complying with the legislation that is in place. Consumer law ensures that businesses act fairly and honestly towards their customers. These laws cover product safety, fair trading, accurate pricing, and consumer rights under the Consumer Rights Act 2015. Ignoring these regulations can lead to penalties and damage the reputation. Businesses must make sure that they follow these regulations and meet the standards of products. An example for consumer rights is if a veterinary practice adheres to consumer protection laws by clearly communicating the cost of treatments, accurately describing the services offered, and ensuring all medications and treatments meet safety standards. They also maintain transparent policies for service cancellation or refunds, ensuring clients are treated fairly and honestly. The next element of it is health and safety, which is a really important element of any workplace, why regulations must be followed, and why health and safety is an important and crucial part of the business. So health and safety, employees must ensure that the workplace is safe. That's the first thing. They must ensure that safe premises and machinery. They must ensure workers' health is not affected by their work. And the key costs and benefits of the Health and Safety at Work Act for business adds to cost to businesses that need to train staff and spend money in maintaining the standards. But it also may reduce cost in the long term because of a reduction in staff absences and not having to pay compensation for injuries. Good health and safety record is a good way of encouraging recruitment of good workers. And a safe workplace is not just good practice, it's a legal requirement. Health and safety laws aim to protect employees, customers, and the public from workplace hazards. In a factory, for example, it has to adhere to health and safety regulations by conducting regular safety training for all employees, equipping them with necessary protective gear, and rigorously maintaining any sort of machinery that is in place. So, you know, they have to follow the laws in place in regards to health and safety. The next one is environmental laws and why they are so important in reference to businesses. So, you know, businesses must ensure they follow environmental laws to comply with any sort of regulations in place in regards to the accountability for environmental impact. So compliance with environmental laws covering things like waste management, emissions, and resource usage is not only a legally obligation, but can also enhance your brand's reputation. So businesses must comply with environmental laws, and non-compliance can result in sanctions, damages, and as I mentioned, brand reputation. An example for this is a manufacturing company adheres to environmental laws by minimizing waste, reducing emissions, and using sustainable materials in the production of the goods. So making sure that they are complying with the laws that are in place, and make sure that, you know, the laws are followed to protect the individual. The next one is data protection and privacy law. And as the GDPR, we mentioned earlier about data protection. Under the Data Protection Act, companies and businesses must protect personal data and store it correctly. So, you know, it's really important that data protection laws are taken into account seriously, as they are non-negotiable. Regulations like the UK GDPR, General Data Protection Regulation, dictate how businesses should collect, use, and store personal data. Non-compliance can lead to substantial fines. For example, a dental practice must comply with data protection laws by ensuring that patient data confidentiality and to secure handling of medical records. Then we've got competition law. So competition law is really important when it comes to businesses, like all the other laws as well. Competition law aims to ensure that the fair competition takes place in each industry. Governments believe that greater competition leads to lower prices, better quality goods, and a wider variety of products. So they need to make sure they comply with them. And competition law laws prevent businesses from engaging in unfair practices, like I mentioned, that may stifle competition. Understanding these laws helps ensure your business competes fairly in the market, and make sure, and that is within the competition law is governed within the Competition Act 1998. An example is a pharmacy chain must comply with competition laws by avoiding practices such as price fixing and other pharmacies, or making exclusive agreements with drug manufacturers that could unfairly restrict market competition and consumer choice. So a summary of that. So we've looked at company law with reference to Companies Act 2006 and the impact on businesses. So it determines companies' formation structures and reporting obligations. We looked at employment law with reference to the Equality Act 2010, National Minimum Wage Act 1998, and it governs the treatment, wages, working hours and safety in the workplace. We looked at Consumer Act, Consumer Protection with reference to Consumer Rights Act 2015, ensuring that goods and services are fit for purpose and quality. Health and Safety Act 1974, and requires working conditions are safe for individuals. Contract law, Consumer Contracts Regulations 2003, governs contracts, transactions between businesses. Intellectual Property, Copyright Designs and Patents Act 1998, protects ideas and inventions. And then Environmental Act 1990 imposes regulations on contracts and sustainability. Data protection, we looked at General Data Regulations, GDPR, and looks at the storage of personal data. And competition law, we've looked at Competition Act 1998, promotes competition and prevents anti-competitive practices. So in conclusion, laws have a profound impact on the various areas of formation and interaction of any businesses. Businesses must comply with these laws. The legal factors that affect businesses are varied and can be complex. Staying informed and compliant is really important. It's not just avoiding any sort of legal pitfalls, but it is a strategy for building reputable, sustainable businesses. Investing in business legal advice and guidance is investing in your business future. So ensuring compliance, fostering, promotes fair practices. So you need to make sure you are compliant with all the laws in place. So now we're going to look at explain how businesses are legally formed. So for you, identifying the right legal, right UK business structure is a crucial part of any business startup. When you start a business, the structure you choose must have significant implications, the amount of tax you pay, the degree of your personal liability should the business fail, the amount of administrative work involved, and even the ability to raise finance. As your business structure defines your legal responsibilities, it's essential to put into time researching the structure. The legal business structure is something you need to decide at the outset and the start of the business, so you know your obligations and your liabilities, although you can change it later if required. All business structures have advantages and disadvantages depending on the factor, or the size of your business, the nature of the business, and the future plans for the business. So the first one we're going to look at, the most common one, is sole trader. And these are the businesses that deal with elements of what different structures we have in place. So, or sole trader, also known as a sole proprietor or sole proprietorship, is an unincorporated business structure and one of the simplest ways to start a business. In a sole partnership, one individual runs and owns the entire company. They typically have full control of how the business is run and the sole autonomy when it comes to building the company's brand. A sole trader is often the only person who works for the business they've created. However, a sole trader can still have employees, but when taking on members of staff, they must register as employers and register for pay with the HMRC. People may become a sole trader alongside full or part-time employment as long as the profits are reported to HMRC. As a sole proprietorship grows, it may be advantageous to restructure as a limited liability company in line with the company's expansion. So many smaller retailers are set up as sole proprietorship, and some examples are things like tradespeople, freelancers, gig economy workers. You know, they will set up as a sole trader. The taxation, so a sole trader keeps all the company's profits after tax has been paid on them, and then paid on them rather than having to share the profits with the partner or shareholders. They also accept sole liability for paying tax on their profits. Unlike incorporated companies, sole traders do not pay corporation tax. Instead, they pay income tax. Tax is paid on not paid on sole traders' turnover, but on their profits. As such, it is a sole trader's responsibility to maintain a detailed profit and loss schedule and use this to fill out their self-assessment tax every year. They could use an accountant for this, you know, so even then, you know, the accountant would do all the work for them. The next one is partnership. Partnership business is one of the most common forms to run a business in the UK. There are several hundred partnerships currently in existence. The most common alternatives are the sole trader and the limited company. Partnerships are often found in professions such as solicitors, architects, things like accountants and doctors, but can be found in any type of business activity. Before setting up a partnership, there are some important things to work out before you start your business, things like the percentage of the ownership of each partner, who contributes to what in the partnership, and whether those assets belong to the partnership or not if the business is later sold or wound up, how profits and losses will be allocated, how decisions will be made at meetings, and possibly whether a partner has a casting vote or more on a particular matter, the principal duties of each partner, the limits of authority of each partner, who makes decisions by themselves. For example, you might agree that no partner can borrow or make an order for more than £1,000 without the agreement of the other. They also will be looking at the procedure for admitting a new partner and the procedure for removing a partner as well. And the taxation, each partnership pays their own share of the income tax. The next one we'll be looking at is a limited liability partnership. Limited liability partnerships are a popular choice for large partnerships providing professional services. For example, things like firms of accountants, architects, or solicitors. A limited liability partnership does not have shares or shareholders, but instead has members. A limited liability partnership is a body corporate with a legal personality separate from its members, primarily governed by the Limited Liability Partnership Act 2000. Limited liabilities must also comply with various regulations such as the Limited Liability Partnership Regulations 2001 and the Limited Partnerships Application of Companies Act Regulations 2009. These regulations modify and apply parts of Insolvency Act 1986 and the Companies Act 2006 to be relevant for LLPs. As a limited liability partnership, you must complete the registration process with Companies House. You should also consider creating a limited liability partnership agreement with other parties. And this document sets out how the business will be run, the rules for sharing power and the rules for sharing profits. Limited liability partnerships must nominate a minimum of 2 designated members who will take on legal responsibilities such as filing the annual accounts, and you will be required to file accounts and send an annual return to Companies House. Accounts will be made by public Companies House, which means you can view them, anyone can view them. Each partner within the limited liability partnership must register as self-employed, which means that they can file an individual tax return. If the limited liability partnership employs people, it will need to operate a payee payroll scheme, make regular returns and pay income tax and national insurance as deducted from the pay of employees to HMRC. The key advantage of having an LLP provides a traditional partnership is that limited liability of the members. The liability of each member is limited to the value of their asset and the partnership. This means that members' personal assets won't be at risk unless they're guilty, wrongdoing, or providing personal guarantees. The next one we've got is private private limited company, referred to as LTD. A private limited company can be small or large business, and it has limited liability, and often these types of business have LTD after the business name. An example of this could be Green Construction Limited. Any type of business can set up as a private limited company. For example, a plumber, hairdresser, photographer, lawyer, dentist, accountant, or driving instructor. The owners of a private limited company are known as shareholders and have to be invited by the business before they can purchase a share of the business. A share is a portion or percentage of a business company. Private limited companies pay corporation tax. Corporation is a tax on the profits of a business. One of the main downside of founding a company as a private limited company is that there's more paperwork to do because the business has to register with Companies House and file annual financial reports. Some advantages of a private limited company are the owners have limited liability. It gives individuals the opportunity to be their own boss. Any shareholders need to be invited, which protects the business from outside influence, and shares in the business can be sold to raise money. Some disadvantages, there is often more paperwork. In some instances, other people are able to view their business financial information. It can be very time-consuming to set up, and the business may require outside professional help to do with its finances. Then we have a public limited company, which is referred to as a PLC. A public limited company is, you may choose this in regards to when your business grows. In a public limited company, the shares are sold to the public on the stock market. People who own shares are called shareholders. They become part owners of the business and have a voice in how it operates. So a chief executive officer, CEO, and board directors manage and oversee the business activities. When a business sells shares on the stock market, this is known as floating on the stock exchange. For a PLC, the business has the ability to raise additional finance through share capital. Also, the shareholders have limited liability, and it's increased negotiation opportunities with suppliers in terms of bid prices because larger businesses can achieve economies of scale. Some of the disadvantages of having a PLC that it is expensive to set up, requiring a minimum set-up cost of £50,000 with at least 25% paid up. There are more complex accounting and reporting requirements. There's a greater risk of hostile takeover by a rival company, as the company cannot control who buys its shares, and shareholders will expect to receive a percentage of the profits as dividends, and shareholders may clash with decisions about the business. So these are the legal structures of the business. So in summary, the table identifies the sole trader with reference to definition, legal formation, process, liability, taxation. An example for partnership, shareholder, limited liability partnership, private limited company, and the public limited company, which we've gone through each elements of it and what legal requirements are applied to that. So businesses in the UK take legal forms, have different elements of it. So, businesses must, follow these elements, and they must comply with this. The fact is that, choosing the right structure is really important, part of running any business, whether you are starting or whether the business is growing. It's about analysing your business goals, for looking at for sole traders to public companies. They all have different legal formation processes and they all operate differently. The right structure depends on the business. As the business grows, you can change the structure and meet your business needs. It's very important that you are, identify your business structure from the start, and see whether it can grow, and then it could change. Many famous companies such as started as sole proprietorship. For example, things like IKEA. They started as sole proprietor in a rural area in Sweden, and then they expanded. And many smaller businesses and self-employed people start as sole traders because it's the easiest legal structure to set up, especially when you are keen to get along with a new venture or when you want to test the market. As the business grows, some small businesses owners make change to limited companies. So it's really important. It's not always easy to decide which legal structure to choose, but you need to look at the financial implications, the financial risks, and the ability to grow as a company and why you want to change it. So now we're going to go on to looking at the impact of key legislation on a business and why that's so important, why it's so important in regards to why there's a need to have legislation. So legislation can play a significant impact on businesses, has a significant both in terms of cost and compliance and the consequences of meeting or not meeting the legal obligations. Businesses must navigate a complex landscape of laws and regulations and must invest in legal advice, training and equipment to ensure they are fully compliant. However, meeting legal obligations can also have a positive impact on the business, helping to improve their reputation and reduce any sort of environmental impact. So compliance is really important when you have to comply with the law. So the first one we'll look at is data protection. Why data protection is so important in any organization. So the General Data Protection Regulations, GDPR, affects all businesses in the UK and that collect personal data about their customers. The law creates obligations on your business around the personal data, how you collect it, and what you do with it. Importantly, the fines for breaching GDPR are substantial. GDPR obviously stands for General Data Protection Regulation. It's a European privacy law that came into force in 2018. Across the whole of EU at that time, it became the effect, and this included the UK. The GDPR rule gave EU individuals rights over their personal data. As a result, GDPR created obligations on businesses that supply or even target individuals living in the EU. Although the UK left the EU in January 2021, GDPR was incorporated into UK law, and that means that UK businesses must comply with GDPR. Personal data is really important information about a person, an individual that relates to them. For example, you can consider any of the following as personal data: a person's name, an identification number like national insurance number, location information, and a person's IP address. GDPR has 7 fundamental principles which underline your obligation as a business. These principles state that personal data regarding individuals must be processed lawfully, fairly and transparently, collected for specified, explicit and legitimate purposes, is adequate, relevant and limited to what is necessary for why you are collecting it, accurate and up to date, kept in a form that allows identification of the individual for no longer than is necessary, and processed in a way that is appropriate security to guard against unlawful access or processes. Essentially, you must comply with these 7 principles as a business and ensure that any third party who possess any data on your behalf comply with these 2. There are several lawful bases for processing personal data. For most businesses in the UK, it is lawful if the individual has consented to you processing their data. You also need certain information to process customers' data. For example, you cannot process a customer's order for the physical goods if you do not have their name and address. Collecting information that allows you to complete the customer order is lawful to GDPR. If you are collecting personal data on the basis that the individual has consented to it, that consent must be explicit. For example, if you have a form on your website which allows a person to sign up for your email newsletter, they must indicate that they understand you will add them to the mailing list. So it's really important that you as a business comply with this. GDPR is really important and it places an obligation on a business to ensure that all personal data based in the UK, EU is kept within the 7 principles and that you are complying with GDPR regulations to make sure that you are not non-compliant, as you could face a heavy fine. The next one is, which is another really, really important part of a business, is health and safety. Health and safety regulations. So workplace health and safety is about sensibly managing risks to protect the workers and the business. Good health and safety management is categorized by strong leadership involving managers, workers, suppliers, contractors, and customers. It's so important is the key requirements. Businesses must conduct risk assessments, identify hazards in the workplace, and implement measures to reduce that. Employers must provide employees with adequate training and safety, Also, businesses must report any workplace accidents or if there's any elements of that. And the law that deals with it is the Health and Safety Act 1974. Adequate training needs to be provided to ensure health and safety procedures are understood and adhered to, and make sure that businesses are assessing any potential risks and identifying any sort of hazards in place, because it's really important that they have a responsibility. There are fines if there's no compliance with health and safety, and dependent on there are civil lawsuits. An example, a manufacturing company must ensure that all machinery is properly maintained, provided employees with safety protection, and making sure that everything is safe to prevent any sort of accidents. So the next one is consumer laws, which again, another important element. The term consumer refers to any piece of government legislation designed to protect consumers from poor quality products and poor business practices. In the UK, there are several pieces of legislation that form the consumer rights, as we mentioned earlier as well. The Consumer Rights Act 2015, Consumer Protection Act 1987, and Trade Description Act. Businesses must follow the Advertising Code of Practice. This ensures that businesses do not use misleading advertising practices and that products are accurately represented to consumers. The government state that all advertising should be accurate, legal, decent, truthful, honest, and socially responsible. The Consumer Protections Act, the Consumer Rights Act, 2015, deals with transactions between a seller and a buyer and is designed to protect consumers from unfair and dishonest practices. And it covers the product or service, returns, repairs, and replacements. Goods and services must be described accurately, so businesses should not describe goods and services in a misleading way. They are fit for purpose. Goods must do what they are designed to do. They have satisfactory quality, so goods should not be damaged or faulty when sold as new, and they must be provided in a reasonable time at a reasonable price. Consumers must be given the right to return, replace, or have a repair for any faulty goods, and businesses must ensure they provide goods and services of an adequate level of quality to meet expectations. And then you've got consequences of that. So if you breach that, businesses may face legal action from consumers seeking compensation or remedies for faulty products, fines and penalties for deceptive marketing or sales practices, damage to business reputation, and loss of consumer trust. An example of that is a business selling electronics must ensure that its products are free from defects, meet the expectations of quality, and are accurately described in marketing materials. If the product is faulty, the businesses must offer a refund or replacement. The next one is employment laws and why they are important in regards to businesses and why there's a need for businesses to comply with them. So all businesses own a general duty of care to their employees. This is codified into a body of law, employment law, that regulates the relationship between the employer and the employee. Employment law is designed to ensure that all employees have channels through which they can make claims if they need to. Employment law clearly has a range of implications for business owners, and it's therefore important that anyone who employs staff understands what's expected of them. Employment law is a body of legislation to protect the rights of employees, as I've mentioned. It clarifies the responsibilities of employees to their employees, and it sets boundaries and provides a framework which disputes can be resolved. Employment law covers things like, working hours, holiday entitlement, minimum pay, sick pay, maternity pay, parental leave, flexible working hours, staff pensions, redundancy, discrimination. Every business has a responsibility to keep up to date with current laws. It can be complex areas that full of pitfalls, so it's important to think through policies and ensure they are implemented with care. The consequences of getting it wrong can be costly and time-consuming. And the Equality Act 2010 mandates that businesses must not discriminate based on the 9 protected characteristics. Businesses must provide safe working conditions. Business owners should be aware of the main elements of employment law and how they affect their businesses. If there's anything about it which are unclear, it's important to get any sort of professional advice. So businesses owners should be aware of recruitment, hours of work, pay, employees' rights, discrimination. This is a complete, it's employment law provides employers with a clear guideline, so they must comply with it. If they do not comply with the laws, employers may face lawsuits for unfair dismissal, discrimination, leading to financial compensation to the employee, penalties for not complying with wage laws or failing to provide statutory benefits, reputational damage due to the workplace, and reputational damage to the workplace discrimination. Example is a company must ensure that all employees are paid at least the national minimum wage and no discrimination occurs in hiring, promotion, or treatment or based on gender or race. So this summary of table looks at the key legislation impacting on businesses. So we looked at the GDPR and we looked at impact of business, key requirements, consequences of non-compliance, and an example. We looked at health and safety at work 1974, and we looked at how it impacted on business, the key requirements to provide safety, consequences, imprisonment, civil lawsuits, an example as well. We looked at Consumer Rights Act 2015 and the impact on businesses, the key requirements, consequences of non-compliance, and an example. And then we looked at employment law and looked at how it regulates fair treatment of employees, no forms of discrimination, and the Equality Act. So in conclusion to that, in UK legislation on data protection, health and safety, consumer protection, and employment significantly impacts on businesses. And businesses must know how to be compliant with the laws and maintain, because it avoids any sort of legal penalties or any sort of lawsuits or civil proceedings against them. Non-compliance can result in serious consequences, as we mentioned, lawsuits, compensation, damage to the reputation. Explain why contractual obligations are important, 4.3. So contractual obligations are fundamental to business operation, ensuring agreements between parties are honoured and legally enforceable. A contract is a legally binding agreement between the parties, and it analyses the terms and conditions of specific arrangement, and much how a blueprint specifies the design and materials for the building. The purpose of a contract is multifold. It ensures that parties involved in business transactions are on the same page, clarifying what each party has agreed to. Key reasons for importance of contractual obligations. So contracts are finalized every second of every day. For businesses in particular, contracts act as a vital tool for building new relationships, extending existing ones, and closing transactions. Contract is a legally binding agreement between two or more parties. Once they sign, this contract agreement creates a promise that certain requirements are made. An example here is a construction company agrees to build a facility for a client. The company's contractual obligation is to complete the project by a specific deadline with an agreed budget and to the required specification. It's there to protect both parties. Contracts protect the interests of both parties involved by clearly outlining their rights, their duties. It's important because it's a legal framework and it's legally binding, enforceable, and the legally binding nature on businesses ensures they have followed the regulations. Example of contractual obligations. So scenario, a marketing firm agrees to create a 6-month advertising campaign for a client. The client is obligated to pay the agreed fee in installment, while the marketing firm is obligated to deliver specific marketing materials by set deadlines. The duty to fulfill a contract, the marketing firm must complete the campaign as agreed. The client must make payments on them. Duty to protect both parties, the contract ensures that client gets the service they paid for, while the marketing firm is ensured of payment as long as it's delivered on the contract. Legally binding. If the marketing firm fails to deliver the campaign materials, the client can seek compensation and enforce the contract. So summary of the importance of contractual obligations. We looked at the duty to fulfill an obligation, protect both parties, and legally binding. Conclusion, contractual obligations are essential to the smooth functioning of a business. They ensure both parties in agreement fulfill their responsibilities by providing legal protection for both parties. And it defines their duties and rights and remedies. Contracts play a crucial part in maintaining trust and stability and is the cornerstone of any business. 4.4, explain how a business could resolve different disputes. So for businesses to resolve disputes, it's important that they are looking at elements of, resolving disputes between the parties. Business disputes are an unfortunate reality of the modern world, but they do not have the detrimental to your business. It's important for business owners to recognize when a dispute arises and deal with it diligently. This involves the underlying causes as well as identifying potential solutions that are beneficial for both parties. So the first one is mediation. Mediation is really important for any business in regards to a mediator will help both parties in a dispute to focus on the issue and consider the way of solving it. The needs of both sides are taken into account and they'll have to find a common ground to find the solution. The mediator is not there to make a decision, but will help both sides to agree a solution. Mediators might be employed by the organisation there are elements of mediation that is ideal for disputes for business relations. So things like key features, non-binding, confidential and collaborative. An example of mediation, a business may use mediation to resolve a contract dispute with a supplier to avoid the high costs of court orders or to build their relationship. Arbitration is another form of, is more formal dispute. Arbitration is probably the best known form of alternative dispute resolution. Is a formal binding process where the dispute is resolved by the decision of a nominated third party who's the arbitrator. In arbitration, the award is enforceable across international boundaries. So key features, it's binding, it's private and it's customable, suitable for commercial disputes, especially those involving complex technical issues, international agreements or contracts where parties want a binding resolution. Example, two businesses in an international trade dispute may turn to arbitration to resolve their disagreement quickly without any sort of delays. Litigation is a formal element of dispute in the court. Litigation, known as dispute resolution process of taking a dispute to court. Disputes refer to disputes between both businesses and individuals and can cover contractual disputes, disagreements between a service provider and client, and other type of disputes. The claimant will begin proceedings against the defendant by issuing a claim to the court. The defendant will then get the opportunity to file a response and potential counterclaims, and then evidence will be presented to the court. This is when the party will get a chance to make their arguments before a judge who will issue a verdict. The litigation process can take a long time as well as have financial impacts on parties. Litigation is also always a stressful process, so businesses should avoid that. Key features are binding, public and appealable. And an example is a business may pursue litigation against a competitor for intellectual property. This table, looks at the legal dispute resolution. So we looked at mediation, arbitration and litigation, and definition, key features, suitable and examples for that. In conclusion, businesses can resolve legal disputes through mediation, arbitration or litigation, depending on the complexity, stakes and the nature of the conflict. Mediation is ideal for preserving business relationships and reaching collaborative solution. Arbitration provides a binding resolution with the benefits of privacy and flexibility. Litigation is more formal and public and necessary for more complex legal issues. Choosing the right method for businesses is effective because you would look at the costing and safeguarding of their reputation. So we finished learning outcome 4. Just to give you a summary of what we've done in learning outcome, we've looked at elements of self-employment, individual registration, incorporation, data protection. We looked at health and safety legislation, consumer laws. We looked at employment laws, the duty to fulfill a contract, contracts against parties, legally binding. We looked at the elements of, going through mediation, arbitration, and litigation. we looked at the law, why they're so important, and laws are so important, and why it's important to comply with them, and why laws have a big impact on businesses, company law, environmental law, consumer law. So we finished learning outcome 4. The next learning outcome is the assignment discussion. These are some of the references we've used for learning outcome 4 that you can link on. There's a collaboration between learning outcome 2, 3, and 4, which they interlink. Some of these books you can look at in regards to it, and links are there for you to refer to as references. Also, plenary, I refer to ebooks and journals on Moodle for this unit. I put a link there, and it's for further reading, effects on business regulations and what impact regulations have on a business. Please have a look at that. Refer to ebooks. This session is recorded and will be available on Moodle for you to, like the other sessions, learning outcome 1, 2, 3, and 4. The next session we will be having is the assignment discussion. So this is the last session of the learning outcomes. Any queries, any questions you have, please email learnerwork@ukvarsity.co.uk, and submission of the assignment is to be done on learnerwork@ukvarsity.co.uk. Assignment submission is after 2 weeks of the completion of the units and its delivery. So you need to make sure, if you need to go on to Moodle to have a read around the learning outcomes, they are all recorded. They will all be on Moodle for you. The assignment brief is on Moodle for you. And the next session we will have is the assignment discussion. So thank you for attending today's session, and I will see you in the next session, which is assignment discussion. Thank you.